Supreme Court Justice Amy Coney Barrett stood at the center of the Washington courtroom, her black robe flowing as she stared down at the silver-haired man before her bench. Liam Neeson, the legendary actor known for his particular set of skills in movies, now found himself facing the highest court in America. "Mr. Neeson," Barrett said, her voice carrying through the hushed chamber, "you claim to have legal expertise that surpasses members of this court? That's quite bold from someone who merely portrays characters for a living," the spectators gasped. The other justices shifted uncomfortably in their seats. Barrett's unusually confrontational tone shocked everyone present. What happened next stunned the entire courtroom. Neeson calmly reached into his briefcase and pulled out a document that no one knew existed. The paper he held would change everything in the next few minutes. In the next 30 seconds, Liam Neeson would reveal something that left Justice Barrett completely speechless and may forever change how America views Hollywood actors in the legal arena. The confrontation that was about to unfold would make legal history. Before diving into this incredible story, comment where you're watching from, and don't forget to like and subscribe so you won't miss our latest political confrontations. For months, Hollywood actor Liam Neeson had been advocating for prison reform in America. His passion wasn't just for show, it stemmed from years of research while preparing for roles as both criminals and law enforcement. What most Americans didn't know was that Neeson had actually completed a law degree in his youth, long before his acting career took off. Justice Amy Coney Barrett, the youngest member of the Supreme Court and a former law professor at Notre Dame, had publicly dismissed celebrity opinions on legal matters. In a recent interview, she specifically mentioned Neeson's prison reform campaign as another actor overstepping their expertise. When a case related to prison sentencing guidelines reached the Supreme Court, Neeson filed an amicus brief, a legal document submitted by someone not directly involved but interested in the case. Barrett, with her sterling conservative credentials and strict interpretation of the Constitution, had been dominating headlines since her controversial appointment. The media portrayed her as brilliant but uncompromising, someone who wouldn't be swayed by emotional appeals from Hollywood. The Supreme Court rarely allows non-attorneys to present arguments, but Chief Justice Roberts, acknowledging the unusual public interest in this case, made an exception. Barrett had openly expressed her disapproval of this decision, setting the stage for a tense confrontation. What made this face-off particularly significant wasn't just the clash of personalities. The case in question would affect thousands of incarcerated Americans. If Barrett's viewpoint prevailed, mandatory minimum sentences would remain unchanged. If Neeson's arguments proved persuasive, it could trigger the most significant prison reform in decades. "I've watched Justice Barrett's meteoric rise," a legal commentator noted before the hearing. "She's never lost a legal argument in that courtroom. Neeson may be used to playing heroes, but today he's walking into a battle he can't possibly win." As Liam Neeson approached the podium to present his arguments, the atmosphere in the Supreme Court crackled with tension. The justices sat in their high-backed chairs, with Barrett's intense gaze fixed on the actor. "Mr. Neeson," Barrett began, before he could speak, "while we appreciate your interest in this matter, this court deals with constitutional law, not Hollywood scripts. I've reviewed your brief and found it lacking in legal substance." Her words were measured, but carried unmistakable dismissal. Several justices looked surprised at this unusual opening. Neeson stood calmly, his famously intense blue eyes meeting Barrett's. "Thank you, Justice Barrett, for your preliminary assessment," he replied, his Irish accent adding gravity to his words. "I understand your skepticism. Perhaps it comes from not knowing that before I ever stepped on a film set, I studied law at Queen's University, Belfast." Murmurs spread through the courtroom. This wasn't public knowledge. Barrett raised an eyebrow. "An undergraduate degree hardly qualifies. I also clerked at the European Court of Human Rights for 2 years," Neeson continued. Though I ultimately chose a different path, the law has always remained my first passion. Justice Samuel Alito leaned forward. Mr. Neeson, while your background is interesting, we're here to discuss constitutional implications of mandatory minimum sentencing, not your resume. Precisely, Barrett added, seemingly relieved by Alito's intervention. And your brief relies heavily on international precedents that have no bearing on American jurisprudence. The tension escalated as Neeson began presenting his arguments. He methodically addressed the Eighth Amendment's prohibition against cruel and unusual punishment, citing obscure Supreme Court precedents that even had Justice Breyer looking impressed. Barrett interrupted repeatedly. Mr. Neeson, in Harmelin v. Michigan, this court clearly established that, with respect, Justice Barrett, Neeson cut in, I was about to address Harmelin. If you will allow me to continue. The back and forth continued for nearly 30 minutes, with Barrett challenging virtually every point Neeson made. The other justices largely remained silent, watching the intellectual sparring match unfold. Then came an unexpected complication. Chief Justice Roberts announced, Mr. Neeson, you're allotted. Time is nearly expired. Barrett smiled slightly, appearing to believe she had successfully run out the clock on Neeson's arguments. But Neeson remained unruffled. Chief Justice, I request a rare extension given the numerous interruptions. I have several critical points that remain unaddressed. Roberts looked at his colleagues and nodded. 5 additional minutes. Barrett's expression darkened as Neeson reached into his briefcase again. Justice Barrett, you repeatedly referenced Harmelin v. Michigan, Neeson said, pulling out a document. I have here the unpublished notes from Justice Kennedy on that very case, which he personally gave me while I was researching for a film role. Notes that provide crucial context to his swing opinion. The courtroom fell completely silent. Barrett's face froze in disbelief. These notes, Neeson continued, explicitly state that Kennedy viewed Harmelin as a narrowly applicable decision, not the broad precedent it's often cited as today. Barrett gripped her pen tightly. Those documents aren't part of the official record. They're not, Neeson acknowledged, but they're authenticated by Justice Kennedy's executor and relevant to understanding the court's own precedent. I've submitted them as a supplemental exhibit. Justice Sotomayor leaned forward with interest. I would very much like to review those notes, Mr. Neeson. As the exchange intensified, legal experts in the gallery began whispering among themselves. This wasn't just theater. Neeson was demonstrating a command of constitutional law that few had anticipated. And Barrett, known for her composure, was becoming visibly frustrated. The tension reached its peak when Barrett said, Mr. Neeson, your portrayal of legal expertise is as fictional as your films. The dismissive comment drew audible gasps from the courtroom. It was a remarkably personal attack from a Supreme Court justice. Neeson paused, his expression calm but determined. The room fell silent, everyone waiting for his response to this direct challenge. Justice Barrett, Neeson began, his voice resonating through the silent chamber. I've played many roles in my career, vigilantes, heroes, villains. But today, I stand before you not as an actor, but as a citizen with a law degree who spent 20 years studying this specific area of jurisprudence. He placed a thick binder on the podium. This contains a statistical analysis of every mandatory minimum sentencing case this court has decided in the past 50 years. Barrett's eyes narrowed. Mr. Neeson, I'm familiar with our precedents. With respect, Justice, Neeson continued undeterred. The analysis reveals something remarkable. In 83% of cases where this court upheld harsh mandatory minimums, the defendants were disproportionately from minority communities. This pattern persists even when controlling for all other variables. Justice Kagan leaned forward with interest. That's a serious claim, Mr. Neeson. It's all documented here. Neeson replied, with methodology reviewed by statisticians from Harvard, Stanford, and Oxford. This isn't about constitutional interpretation in the abstract. It's about how these precedents have been selectively applied. Barrett's face flushed slightly. The statistical correlation doesn't prove. Which brings me to my final point, Neeson continued, pulling out his most powerful evidence. Justice Barrett, in your Notre Dame Law Review article from 2017, you yourself wrote, and I quote, "Statistical evidence of disparate impact should be considered when evaluating Eighth Amendment claims." The courtroom erupted in murmurs. Barrett appeared momentarily stunned as Neeson displayed the article on the court's presentation screen. "You advocated precisely the approach I'm presenting today," Neeson said quietly. "I'm simply asking you to apply your own scholarly standard to this case." The decisive moment had arrived. Barrett, known for her consistent judicial philosophy, was faced with her own words. Justice Thomas, who rarely speaks during oral arguments, cleared his throat. "Mr. Neeson, while your statistical analysis is impressive, how do you reconcile it with the court's traditional deference to legislative determinations regarding sentencing?" The room fell silent again. Thomas's question wasn't hostile. It was substantive, treating Neeson as a serious legal thinker rather than a celebrity. Neeson turned to face Thomas directly. "Justice Thomas, I believe that deference has limits, particularly when fundamental rights are at stake. In McCleskey v. Kemp, you joined the majority that rejected statistical evidence of racial bias in death penalty cases. But crucially, the court left open the possibility that stronger statistical evidence could prevail in future cases." He pulled out another document. "I've analyzed the exact threshold suggested in Justice Powell's majority opinion, and our current data exceeds it by a factor of 3. Thomas nodded slowly, his expression thoughtful. Neeson continued, "Furthermore, Justice Thomas, in your own separate opinions, you've emphasized that the Constitution must be interpreted in light of its original public meaning. The historical record shows that the framers of the Eighth Amendment and the 14th Amendment specifically intended to prohibit punishment systems that disproportionately target minority groups." Heads turned toward Justice Thomas, who was known for his originalist approach. The fact that Neeson was engaging with Thomas's judicial philosophy at such a sophisticated level stunned the courtroom. Justice Alito, typically skeptical of expansive Eighth Amendment interpretations, leaned forward. "Mr. Neeson, your historical analysis notwithstanding, are you suggesting that the court should invalidate sentencing schemes enacted by democratically elected legislatures based on statistical patterns alone?" Neeson shook his head. "No, Justice Alito. I'm suggesting that when statistical evidence reaches a certain threshold, it creates a rebuttable presumption that should shift the burden to the government to prove that a sentencing scheme serves a compelling interest that cannot be achieved through less restrictive means." "And where in our precedent do you find support for such a burden-shifting approach?" Alito pressed. Without hesitation, Neeson replied, "In Johnson v. California, this court held that when a prisoner presents evidence raising an inference of racial discrimination, the burden shifts to the state to offer a legitimate reason for its actions. The same principle should apply here." Alito sat back, visibly impressed despite himself. Justice Sotomayor, known for her focus on the real-world impact of legal decisions, jumped in. "Mr. Neeson, beyond the statistics, could you speak to the human cost of the current approach?" "Gladly. Justice Sotomayor," Neeson replied, his tone shifting slightly. "Behind these statistics are real people. I've spent time in over 30 prisons across America while researching roles. I've met individuals serving 25-year sentences for nonviolent drug offenses that would receive probation in other jurisdictions. I've seen families torn apart, communities decimated." He pulled out a series of photographs. "These are images from communities with the highest rates of incarceration under mandatory minimum laws. The economic impact alone costs taxpayers billions, while destroying the social fabric of these neighborhoods. Barrett, recovering from her initial surprise, interjected, "Mr. Neeson, emotional appeals." "These aren't emotional appeals, Justice Barrett," Neeson corrected firmly. "These are documented socioeconomic impacts that the court has recognized as relevant in cases from Brown versus Board to Obergefell. The stability of communities is a constitutional concern when rights are at stake." Chief Justice Roberts, who had been observing the exchange carefully, asked, "Mr. Neeson, if the court were to accept your argument, what limiting principle would you propose? How would judges determine which statistical disparities cross the constitutional threshold?" It was the kind of nuanced question typically reserved for experienced Supreme Court advocates, and Roberts was asking it of an actor. Neeson didn't hesitate. "Chief Justice, I propose a three-part test. First, the disparity must be statistically significant at the 95% confidence level. Second, it must persist across multiple jurisdictions with similar laws, ruling out local anomalies. Third, it must be consistent over time, demonstrating a pattern rather than a temporary fluctuation." The level of specificity in Neeson's answer surprised even the most seasoned court watchers. This wasn't an actor reading lines someone else had written. This was a deeply knowledgeable legal mind articulating a sophisticated constitutional test. Barrett, realizing she needed to engage substantively rather than dismissively, asked, "And how would your test apply to other areas of criminal law beyond mandatory minimums?" "It wouldn't automatically apply elsewhere," Neeson replied. "The test I'm proposing is specific to sentencing because the Eighth Amendment creates unique constraints on punishment that don't apply to other aspects of criminal procedure." Barrett nodded slowly, making notes. Justice Kagan, known for her strategic questioning, posed what might be the most important inquiry. "Mr. Neeson, assuming we find your statistical approach persuasive, what specific remedy would you have this court impose?" "Justice Kagan, I'm not asking the court to invalidate all mandatory minimums," Neeson clarified. "Rather, I propose that when a mandatory minimum scheme produces statistical disparities that meet the three-part test I outlined, courts should have discretion to consider whether the sentence would be grossly disproportionate as applied to the individual defendant before them." He continued, "This approach respects the legislature's role in establishing sentencing guidelines while ensuring that individual cases don't produce constitutionally prohibited outcomes." Justice Kavanaugh, who had been silent until now, spoke up. "Mr. Neeson, your argument seems to blend elements from both liberal and conservative judicial philosophies. Was this intentional?" Neeson smiled slightly. "Justice Kavanaugh, I believe constitutional principles transcend political labels. From Justice Scalia, I draw the importance of clear, administrable rules. From Justice Ginsburg, I take the recognition that the Constitution must protect vulnerable minorities. Both perspectives have value." The answer seemed to resonate with Kavanaugh, who nodded appreciatively. Chief Justice Roberts broke the tension. "Justice Barrett, would you like to respond to Mr. Neeson's citation of your article?" Barrett gathered herself, then said something that shocked the courtroom. "Mr. Neeson, you have correctly quoted my article, and your analysis deserves serious consideration." The admission sent ripples through the gallery. Legal reporters frantically took notes. Barrett, who had never publicly reversed course during oral arguments, had just acknowledged the merit in Neeson's presentation. She continued more measured now. "I would note, however, that the article you cited was written in an academic context, not a judicial one." "The standards of evidence may differ." Neeson nodded respectfully. "Of course, Justice Barrett. But the intellectual consistency of your approach is what I found most compelling. You argued then, as a scholar, that constitutional principles shouldn't be applied differently based on who benefits. I'm simply suggesting that the same intellectual honesty should inform your jurisprudence. It was a masterful response, respectful yet pointed. Barrett seemed to recognize the elegant trap Neeson had laid. If she dismissed the relevance of her own scholarly work, she risked appearing intellectually inconsistent. If she acknowledged its relevance, she would have to seriously consider Neeson's arguments. After a moment's consideration, she said, "Your point is well taken, Mr. Neeson. The court should strive for intellectual consistency." The admission elicited audible reactions throughout the courtroom. Everyone present recognized they were witnessing something extraordinary. A Supreme Court justice acknowledging the merit of an argument from someone she had initially dismissed. For the remainder of his time, Neeson laid out a compelling constitutional argument against overly rigid mandatory minimums that had several justices nodding thoughtfully. He concluded with a powerful statement. This court has never shied away from correcting course when evidence reveals that our legal system is falling short of constitutional promises. From Brown overruling Plessy, to Gideon expanding the right, to counsel, the court has recognized that justice requires both wisdom and courage. Today, I'm asking for that same wisdom and courage. When he concluded, the traditional thank you counsel from the Chief Justice was followed by an unusual moment of silence, the kind that follows when everyone recognizes they've witnessed something extraordinary. As Neeson returned to his seat, legal experts in the gallery exchanged glances. The actor hadn't just held his own against one of America's most formidable legal minds. He had presented an argument so compelling that it might actually change the outcome of the case. Barrett watched him walk back, her expression unreadable, but her legal pad filled with notes. For perhaps the first time in her Supreme Court tenure, she had met an intellectual equal from a completely unexpected source. A senior Supreme Court reporter from CNN whispered to his colleague, "I've covered this court for 20 years. I've never seen anything like what just happened." Within hours of the Supreme Court hearing, Yarn Neeson vs. Barrett was trending nationwide. Legal blogs exploded with analysis, and video clips of the exchange went viral, accumulating millions of views. The moment when Barrett acknowledged the relevance of her own scholarly article became the most shared clip, generating over 6 million views in just 24 hours. CNN's special coverage began immediately after the court adjourned. Legal analyst Jeffrey Toobin appeared visibly energized on air. What we witnessed today was unprecedented. Liam Neeson displayed a level of legal acumen that stunned the court. Justice Barrett's initial dismissiveness gave way to genuine engagement with his arguments. This could represent a turning point in how the court approaches mandatory minimum sentencing. On the same panel, former Supreme Court clerk Nina Totenberg added, "I've been covering the court for 4 decades, and I've never seen a justice as composed as Barrett visibly reconsider her position during oral arguments. The significance cannot be overstated." SCOTUS blog, the leading Supreme Court analysis site, published a detailed breakdown titled, "The Actor and the Justice, a Constitutional Showdown." The article concluded, Barrett's acknowledgement of Neeson's points may signal a shift in her Eighth Amendment jurisprudence, or at least a willingness to reconsider her position. More broadly, it raises fascinating questions about expertise in constitutional interpretation. Legal Twitter, now part of X, erupted with commentary from law professors and practitioners. Harvard Law's Lawrence Tribe posted, "Neeson's performance today ranks among the most effective Supreme Court advocacy I've witnessed. His 3-part test for evaluating statistical evidence in Eighth Amendment cases is both novel and compelling." Fox News took a different angle. Hollywood elite lectures Supreme Court read their Chiron, though even their legal commentators acknowledged Neeson's preparation had been exceptional. Laura Ingraham began her show saying, "While I'm skeptical of celebrities inserting themselves into legal matters, it's clear that Neeson came extraordinarily prepared. The question is whether his statistical approach upholds constitutional principles or undermines them." Conservative legal scholar Jonathan Turley wrote in The Hill, "Regardless of one's position on mandatory minimums, Neeson's articulation of constitutional principles was sophisticated and nuanced. It's a reminder that legal expertise can come from unconventional backgrounds." By the next morning, the story had transcended legal circles. Major newspapers ran front-page headlines. Washington Post, "From taken to taking on the Supreme Court, Neeson stuns legal world." New York Times, "When Barrett met her match, actor's legal brilliance reshapes court dynamics." Wall Street Journal, "Supreme drama, Neeson's statistical approach challenges sentencing precedents." The following morning, Neeson appeared on Good Morning America. When asked about the confrontation, he remained humble. "I have immense respect for Justice Barrett and the entire court. My goal wasn't to win an argument, but to ensure that the human impact of these legal decisions was fully considered." When pressed about his legal background, he elaborated slightly. "I studied law before acting took over my life. The interest never faded. For the past 20 years, I've been involved with the Innocence Project and similar organizations, seeing firsthand how mandatory minimums affect real people. Those experiences informed my approach yesterday." The interviewer asked about his preparation for the Supreme Court appearance. Neeson's answer stunned viewers. "I spent 8 months preparing. I read every Supreme Court case on sentencing from the past 50 years. I studied each justice's writing style, judicial philosophy, and questioning patterns from previous oral arguments. I prepared responses for over 200 potential questions." Meanwhile, legal education was experiencing immediate impacts. Law schools across the country were requesting the transcript of Neeson's oral argument for use in their constitutional law classes. Georgetown Law announced a new seminar titled "Advocacy Beyond Tradition: Lessons from Neeson versus Barrett." A professor from Yale Law School tweeted, "Teaching my students that masterful advocacy can come from unexpected places. A Neeson vs. Barrett case study coming fall semester." The moot court competition circuit quickly incorporated elements from the exchange. The National Moot Court Competition announced that its next problem would involve statistical evidence in Eighth Amendment challenges directly inspired by Neeson's arguments. Politics, too, felt the ripple effects. Senator Dick Durbin, chair of the Judiciary Committee, announced hearings on mandatory minimum reform, citing compelling new constitutional arguments that deserve legislative consideration. Several state legislatures began reviewing their sentencing guidelines. Social media platforms filled with personal stories from families affected by mandatory minimums. A viral TikTok series featured children reading letters to the Supreme Court about parents incarcerated under harsh sentencing laws. Each video ended with the hashtag "On Statistics Air People," echoing a phrase Neeson had used during his argument. The broader implications began to emerge in the weeks that followed. Other entertainment figures with specialized knowledge beyond their public personas started speaking more confidently on issues of policy. Emma Watson, with her degree from Brown, addressed the UN on education policy with renewed authority. Scientists took actors with relevant degrees more seriously on environmental issues. The most significant development came 1 week later. Justice Barrett took the unusual step of giving a speech at Georgetown Law Center. Without specifically mentioning Neeson, she addressed the broader issue. "The legal community must guard against intellectual insularity," she said to a packed auditorium. "We should evaluate arguments based on their merit, not their source. Sometimes the most valuable perspectives come from beyond our traditional circles." She continued, "As jurists, our commitment must be to the Constitution and to justice, not to our preconceptions about who can contribute meaningfully to constitutional dialogue. When we dismiss arguments based on their source rather than their substance, we risk missing important insights." The audience, composed mainly of law students and faculty, gave her a standing ovation. something almost unheard of for a sitting justice at an academic venue. Legal analysts immediately recognized this as an oblique reference to her exchange with Neeson. Washington Post's Supreme Court reporter wrote, "Barrett's Georgetown speech represents a remarkable moment of judicial growth, a willingness to publicly acknowledge that her initial approach to Neeson's arguments had been unnecessarily dismissive. It's particularly notable from a justice who has rarely displayed this kind of public introspection." Conservative commentators were divided. Some praised Barrett's intellectual honesty, while others worried she was being influenced by Hollywood liberalism. National Review published a thoughtful piece titled "Barrett's Principles: When Consistency Requires Reconsideration," arguing that her response demonstrated judicial integrity rather than weakness. Behind the scenes at the Supreme Court, the impact was even more profound. Sources close to the court reported that during the justices' private conference, Barrett had initiated a detailed discussion of Neeson's statistical methodology. According to one clerk who spoke anonymously, Justice Barrett acknowledged that the data warranted serious scrutiny, essentially adopting the position she had initially dismissed during oral argument. The court's opinion on the mandatory minimum case wouldn't be released for months, but clerks familiar with the court's internal discussions leaked that the justices were deeply divided, with Barrett reportedly wrestling with the statistical evidence Neeson had presented. Legal scholars began publishing articles anticipating the court's decision. A Harvard Law Review piece analyzed the potential implications. If Barrett sides with the liberal justices, it could represent the most significant shift in Eighth Amendment jurisprudence since Furman versus Georgia, and all catalyzed by an unlikely advocate. 3 months later, when the decision was finally announced, legal experts were stunned. In a 6-3 opinion authored by Chief Justice Roberts, with Barrett joining the majority, the court established new guidelines requiring lower courts to consider statistical evidence of disparate impact when evaluating Eighth Amendment challenges to mandatory minimums. The opinion incorporated elements of Neeson's proposed 3-part test, requiring statistical significance, persistence across jurisdictions, and consistency over time before finding a constitutional violation. Legal commentators immediately noted the test's resemblance to Neeson's oral argument. Barrett's concurrence was even more explicit. She wrote, "When confronted with compelling statistical evidence that meets rigorous methodological standards, courts cannot simply dismiss the constitutional implications. The Eighth Amendment's prohibition on cruel and unusual punishment must be interpreted in light of evolving standards of decency, and those standards include our growing understanding of systemic disparities." She added a footnote specifically citing the statistical methodology presented during oral arguments, a clear nod to Neeson's contribution. The dissent, authored by Justice Alito and joined by Thomas and Gorsuch, argued that the majority was substituting statistical analysis for constitutional interpretation. The Constitution assigns sentencing policy to legislatures, not statistical models, Alito wrote. But the majority had spoken. The practical impact was immediate and far-reaching. Within a year, federal courts had reviewed over 3,000 sentences under the new framework, with nearly 40% resulting in reductions. The human impact was profound. Families reunited, communities restored, and a criminal justice system nudged closer to equity. The Bureau of Prisons reported a 12% reduction in federal prison population within 18 months, saving taxpayers billions while reducing overcrowding. States began voluntarily revising their own sentencing guidelines to align with the court's new approach, amplifying the impact. Criminal justice reform advocates celebrated the decision as a landmark victory. Brian Stevenson of the Equal Justice Initiative called it the most significant criminal justice reform in a generation, while noting the unusual circumstances that produced it. Neeson never publicly took credit for the shift. When asked about his influence during a subsequent film promotion, he simply said, "My expertise is acting." I just happen to have some knowledge that might help people who've been overlooked by our system. Justice Barrett and the court made their decision based on the law, not my presentation. Nevertheless, his advocacy had unexpected career implications. Prestigious law schools began inviting him to give guest lectures on effective advocacy. The American Bar Association awarded him its highest civilian honor for contributions to the legal field. A documentary titled The Advocate followed Neeson as he visited prisons to meet individuals who had benefited from the court's new approach. The media narrative evolved from initial shock to deeper analysis. The Atlantic published a cover story titled Expertise in America, Rethinking Authority in the Age of Specialists, using the Barrett-Neeson exchange as its central case study. The piece argued that traditional credentials were increasingly poor predictors of genuine expertise. Law schools adjusted their teaching to reflect the lessons of the case. Harvard Law added a new course on statistical evidence in constitutional law, while Yale revised its moot court program to include more diverse advocates. Georgetown Law established the Neeson Fellowship for legal advocates from non-traditional backgrounds. History would remember the unlikely confrontation between the actor and the justice as a pivotal moment. Law school textbooks would eventually include a section on the case, noting how it demonstrated that substantive legal arguments can come from unexpected sources. Political scientists studied how the case influenced public opinion on the Supreme Court. A Gallup poll found that public trust in the court increased 8% following the decision, with respondents citing the justice's willingness to consider new perspectives as a key factor. The most personal aftermath remained private until years later, when Justice Barrett's memoir was published. In a chapter titled Unexpected Teachers, she wrote, "My initial reaction to seeing Mr. Neeson approach the podium was admittedly dismissive. I had categorized him based on his profession rather than his arguments. That day taught me a valuable lesson about intellectual humility that has informed my jurisprudence ever since." She continued, "The experience forced me to confront my own biases about expertise and authority. I realized that while my academic training provided valuable tools for constitutional interpretation, it also created blind spots. Sometimes an outsider's perspective illuminates aspects of justice that those within the system have overlooked." The memoir became a bestseller, with that chapter particularly resonating with readers. In interviews promoting the book, Barrett acknowledged that the Neeson case marked a turning point in her judicial philosophy. "Before that day," she told 60 Minutes, "I believed my role was primarily to interpret text and precedent. After the exchange with Mr. Neeson, I developed a deeper appreciation for how those interpretations affect real communities. My commitment to textualist principles hasn't changed, but my understanding of their impact has broadened significantly." Legal historians would later identify the Barrett-Neeson confrontation as a key moment in the evolution of the court's Eighth Amendment jurisprudence. Georgetown law professor Paul Butler wrote in his definitive history of the court, "The exchange demonstrated how the court's understanding of constitutional principles can evolve through dialogue with voices outside traditional legal circles." The story of Barrett and Neeson became more than a viral moment or legal anecdote. It evolved into a parable about expertise, humility, and the unexpected ways justice can advance in America. As for the wider public, the confrontation remained a fascinating example of what happens when brilliant minds collide, and how sometimes the person society expects to win isn't always the one with the better argument. The real lesson wasn't about celebrity or judicial power, but about preparation, respect for facts, and the courage to advocate for justice, regardless of who sits in judgment. 10 years after the famous exchange, a reporter asked Neeson if he was surprised by the lasting impact of his Supreme Court appearance. His response captured why the story continued to resonate. "I think people respond to authenticity and preparation," he said. "I didn't try to be a lawyer that day. I brought my full experience. My legal knowledge, yes, but also what I'd learned, visiting prisons, talking to families torn apart by these sentences. Justice Barrett responded to that authenticity with her own, acknowledging when a point deserved consideration, regardless of who made it. That kind of intellectual honesty is rare and powerful. This incredible showdown between Justice Barrett and Liam Neeson shows us that assumptions about expertise can blind even the brightest legal minds. It reminds us that justice sometimes comes from unexpected places, and that powerful arguments, backed by facts and delivered with conviction, can change minds and ultimately change lives. If you found this story as fascinating as we did, don't forget to like this video and subscribe to our channel. We'll be bringing you more incredible legal confrontations and political showdowns that shaped America. Leave a comment below telling us which Supreme Court justice or celebrity legal expert you'd like to see featured next.